Welcome, I'm Ron Collins. Welcome to the First Amendment Salon. And before we start, please turn off your phones. So if you're expecting a call from your Uncle Albert, you're not going to get it today, so please turn off those phones. Also, by way of an announcement, this salon, like all others, will be video recorded, so please keep that in mind, and it will be posted on the website of the Foundation for Individual Rights. More about that in a moment. But thank you for all joining us today on Lincoln's birthday, President Lincoln's birthday, February 12th. And as I said, I'm Ron Collins, and I am one of the co-chairs of the First Amendment Salon, along with my colleague Lee Levine, who's in California today, and David Scover, who's in Seattle, but I'm here in Washington, D.C. And greetings to New York. We're delighted to have you there and join us here in Washington, D.C. This is our 16th salon. We're very excited, going back to April of 2014. And as those of you who have attended earlier salons know, that the whole purpose of these salons is to discuss, debate First Amendment issues, speech, press, petition, assembly. We stopped there. Sorry, we don't do religion. But in a robust and civil way. And so far, we've been able to do both. And I think that tradition will continue. The First Amendment salons are lawyers involved in First Amendment cases, professors, journalists, activists, so a wide range of folks. For those of you who have been with us before, welcome back. For the newbies, welcome. We hope you join us again for future salons. Speaking of future salons, we will have one coming up very soon in April. And our next salon will be at the Floyd Abrams Institute at Yale Law School on April 27th. So mark your calendars. On April 27th, we'll be at Yale Law School, video cast to Washington, D.C. and New York. The nature of that event will be is still being determined, but it's April 27th at the Floyd Abrams Institute at Yale Law School. So please keep that in mind. We are especially pleased, and tonight is the first time that we've been at the offices of this wonderful firm, Ballard Spahr, our new sponsor, and we're very appreciative to have them help us out, and it means a lot to us. And I'm particularly pleased to have been working with Wendy Iverson and continue to be working with Bridget Conti now with this firm. And so again, we look forward to a lot of good programs with Ballard Spahr. And again, sincere thank you to them for making the salons possible. Now, as I said, today's salon will be videotaped. And in that regard, we're going to be talking about an important case, Masterpiece Cakeshop versus Colorado Civil Rights Commission. By the way, if you're in New York, you don't see it. We have a wedding cake here, half of which says liberty, the other half says equality. So we'll see who eats which side after the event.
You don't have to eat it, though, do you?
You don't have to, no, but it's a very high.
Nobody's going to force you to eat it?
It's a very high-end cake, so
it's compelled eating.
We'll see what you can do. In any event, I don't want to spend too much time because I want to cut right to the chase here. So let me introduce our participants for today's program. Steve Wermiel will be our moderator, and he's going to moderate today's discussion. He's a professor of practice in constitutional law at American University College of Law. You may know Steve. He is the co-author of the definitive biography of Justice Brennan, called Justice Brennan, Liberal Champion, a biography that he did with our own Lee Levine. And he's also co-author, again with Lee Levine, of the progeny, Justice William Brennan's Fight to Preserve the Legacy of New York Times versus Sullivan. Welcome, Steve, and thank you for doing this. Arguing on behalf of the petitioner Baker, let's start off with Robert Corn-Revere. He's a partner at Davis, Wright, Tremaine, a seasoned First Amendment litigant. He successfully argued United States versus Playboy Entertainment Group in the United States Supreme Court. But more importantly, far more important than that victory in the United States Supreme Court, is that he, along with his colleagues at Davis Wright, secured a posthumous pardon for Lenny Bruce. So on that note, welcome, Bob. We're delighted to have you. He will be joined on his side by Ilya Shapiro, right here. Ilya is a senior fellow in constitutional studies at the Cato Institute. He's the editor-in-chief of the Cato Supreme Court Review. He's the co-author of Religious Liberties for Corporations. And he is the most active appellate litigant. Some 300 amicus briefs filed in the Supreme Court and elsewhere. And so we're happy to have him today. Welcome, Ilya. Arguing on behalf of the respondent, Colorado Civil Rights Commission, John Paul Schnapper-Casteras. Welcome, JP, if we can take the liberty. He has just opened an appellate law boutique firm here in Washington, D.C., doing civil rights and constitutional cases. So we look forward to hearing more about that firm. Good luck with that. Before that, he was special counsel for appellate and Supreme Court advocacy at the Legal Defense Fund. In that role, JP worked with LDF attorneys on strategic development and preparation of cases to be argued in the Supreme Court. He also argued by way of an amicus brief on behalf of lesbian and gay rights service members in the landmark case of United States versus Windsor. Welcome, JP. We're happy to have you. And finally, Sarah Warbelow. She is the director of the Human Rights Campaign. She leads the campaign's team of lawyers and fellows focused on federal, state, and municipal policy. She coordinates the campaign's advocacy efforts as amicus curiae in litigation affecting the LGBTQ community. And she has been with the campaign since 2008, and she has served in a number of capacities in that regard. Sarah, we're delighted to have you. Welcome to the First Amendment Salons. With that, Steve, my job is done. I turn it over to you for an uninhibited, robust, and always wide open discussion. Steve, it's yours.
Thank you, Ron. Thank you all for being here. Thank you in New York. And thank you for hosting us here. We're delighted to get into the discussion. We are, of course, talking about Masterpiece Cakeshop versus Colorado Civil Rights Commission. I'm sure most people are familiar with it. I'll give you the 30-second version. Jack Phillips, a baker in Lakewood, Colorado, declined to provide a wedding cake to a same-sex couple who wanted to be married, Charlie Craig and David Mullins. In 2012, they filed a complaint with the Colorado Civil Rights Commission, which ultimately ruled in their favor. And the Colorado Court of Appeals agreed with them and the Civil Rights Commission, ruling that the baker had violated Colorado's anti-discrimination laws by refusing to provide the cake. The Colorado Supreme Court declined further review, and the U.S. Supreme Court granted cert, heard argument in December 2017, and we await decision, and here we are. To quickly frame the issues, and I'd rather let our panelists do that, but in simplest terms, this basically is the question of whether free speech triumphs over civil rights law or the other way around, and that's what we're going to get into right away here. Let me start with the free speech side of things. I don't think I've ever seen a case, and I've been watching the Supreme Court for about 50 years now, pains me to admit that, that has divided the First Amendment community as much. There are amicus briefs on both sides of the case by respected and passionate First Amendment advocates. Bob Corn-Revere is on one side of that, and let's let him start with why. Is this compelled speech? Why do you see it that way?
Okay. First, a couple of things. One is I want to acknowledge my colleague, Ronnie London, who was originally slated to sit in this chair. Ronnie is my longtime collaborator in all of these cases. He and I did a brief together, an amicus brief on behalf of the First Amendment Lawyers Association in this case, and so he was going to be here. He ended up having a conflict that made him have to cancel, but then at the last minute, he was able to come. So such is the life of the litigator, and it's why I'm stuck here and not Ronnie. But anyway, thank you for...
Why you're thrilled to be here.
I am thrilled to be here, and thank you for the opportunity. The reason that, and let me also say that, as you point out, this is a case that really does divide many people in the First Amendment community. It's one of the many reasons that makes this case a really difficult case. I mean, one is particularly when you sympathize with the other side so much. When you look at the emotional toll of a case like this, it's hard not to want to be on the other side. And it's one in which there are so many people, many in this room, many in New York, and many who filed one of the 100 or so amicus briefs in the case, that made very impassioned arguments. People who I respect, people who I normally agree with, are many of them on the other side, many of them on my side. I can tell you as well that there was a robust debate within the membership of the First Amendment Lawyers Association, and ultimately the decision was made to file the brief because of what we saw as the important First Amendment principles involved. In many ways, it reminds me of the decision that we made, and many others did too, in the Westboro Baptist Church case, Snyder versus Phelps, where it is hard to find a more sympathetic party on the other side and someone who you are never going to agree with on the side in which you file a brief supporting, in that case, the Westboro Baptist Church. In that case, I thought one of the Fourth Circuit judges in the case really said it best, and this is something that we quoted in our brief, and that is to say, those who defend the Constitution must sometimes share their foxhole with scoundrels of every sort, but to abandon the post because of the poor company is to sell freedom cheaply. It is a fair summary of history to say that the safeguards of liberty have often been forged in controversies involving not very nice people. And so it comes down really to, I think, the First Amendment principles here. Now, in many cases, and a lot of the reporting on this is to say, oh, come on, it's just cake. You're talking about food, where's the First Amendment issue? And the problem is that once you agree that there is a symbolic element, once you agree that, or if you agree that there is some degree of expression here, then it's difficult to get away from the First Amendment issue. As a matter of fact, the Colorado Court of Appeals agreed that a baker that had a valid First Amendment claim could refuse to bake a cake under the public accommodation law because if there was a sufficiently particularized message, then that would justify refusal to bake the cake. There were even a couple of cases in Colorado that reached the same conclusion, basically saying that a baker could refuse to bake a Bible-shaped cake with an anti-gay message on it, and that it had a First Amendment right not to do that. So it doesn't matter if it's just food. It's easier to envision if you see this as a prohibition of speech than as compelled speech. So, for example, if someone prohibited school children from bringing rainbow-themed cupcakes to school in celebration of tolerance and acceptance and all of that, then I think most of the people in this room would agree that there was a First Amendment issue here, saying that you can't, through the symbolism of food, express some sort of idea. Even if there are no words involved, even if it is purely symbolic, then it does represent some kind of First Amendment issue. That's really what was at issue here. It wasn't a simple refusal to serve case where someone comes into a bake shop and you say, oh, you're gay, I'm not going to serve you. In fact, if you read the record, and it's a very thin record below, you find that the couple came in, and when the baker explained that he wasn't going to create a custom cake for them, said, I'll sell you anything else in the store, I'll sell you cookies, I'll do a birthday cake, because of my beliefs, I can't create a wedding cake. So it's not as simple as, say, you can't come to my lunch counter. It's not a refusal to serve case. It's a question of whether or not someone can be forced to create some kind of expressive art. The second issue is this, and that is, can someone be compelled, if you agree that there is an artistic component, can someone be compelled to create art? Now, I challenge anyone in this room, anyone in New York, to name one case where someone has been forced to create a work of art. If anyone can name a First Amendment case where that's true, then we can have an entirely different discussion. But we searched for that. As a matter of fact, the First Circuit, in a case from the 1980s, looked for the same kind of thing in a case involving the Massachusetts civil rights law and whether or not the Boston Symphony Orchestra could be compelled to do a performance. And they were unable to find any decision saying that you can be compelled to create a work of art. So it's not a question of whether or not the baker was, by association, supporting gay marriage. It's not a question of whether or not he was sending a particularized message. The question is whether he does art, creates art for his living, and whether or not he can be compelled to do that. And the Supreme Court has addressed that in similar circumstances, in whether or not a parade can be forced under Massachusetts civil rights law to be compelled to have an expressive unit continued as part of that parade. And in that case, the Supreme Court said, completely contrary to the Colorado Court of Appeals below, that it doesn't matter whether or not there is some sort of particularized message, that we protect modern art, we protect instrumental music, and all of that because the First Amendment doesn't require that kind of particularized message. Long answer to a short question, but there it is.
Let me turn to JP and get the civil rights side of this for starters. Then I have some more questions.
Sure. So just in terms of how to frame the issue here, I think it helps to go back to the facts just for a second. And you've summarized them quite aptly. We have a small business owner who sells specialty foods, and you have three individuals who walk into that store and are turned away. Either turned away entirely because of who they are, and the small business owner has religious beliefs that say, I cannot serve that particular type of person, or turned away partly, that is to say, offering certain types of products and services and not others. And then when challenged in court, the small business owner invokes the First Amendment, either free exercise or free speech clause, or both. I could be talking about what happened to Mr. Craig and Mr. Mullins and Ms. Munn here in this case that we're discussing today in 2012 in the Masterpiece case. But what I'm actually describing is what happened to three African-American consumers in 1964 in the Newman versus Piggy Park case. There too, there was a small business owner who was later described to be an artist. He had a very special type of food, it happened to be barbecue, that he served. He too had religious beliefs, whatever we might think of them now, that were undoubtedly firmly held. He believed that contributing to racial intermixing in any way, quote, contravened the will of God. That's what he believed. And so when a black customer who happened to be a Baptist minister walked into the store, he stood in the doorway and turned them away. And then later, when two other African-American customers came in and tried to purchase products, he said, well, you can go around back and you can get the takeout food, but you can't have the food here. So he would offer them some of the products, but not others. And I think this is a distinction that's already started to come up, that's going to come up more. So I raise that example not just because I think the factual parallels are rather striking, but also because I think the legal precedent is highly relevant and forces us to see this case in a different light. And that's because the Supreme Court unanimously held that the First Amendment could not justify differential treatment under then recently created federal public accommodations law to turn away people on the basis of who they are. And that's essentially the theme and the focus of the brief that the NAACP Legal Defense Fund, when I was there, filed, and that is the core prism through which I see the case.
Oh, and let me just say, I agree with the first 20 pages of your brief. It's the last 4 pages where you try and make the leap from the Piggy Park case to First Amendment expression that I can't really agree. It's one of the reasons why, at least in the First Amendment Lawyers Association briefs, we said that the court should not address the free exercise claim because that would allow any bigot with a Bible or a Koran to simply say, I'm not going to serve you. That's not what I think the court should address. I think it should focus purely on the expressive elements. And in that case, whether or not some barbecue cook calls himself an artist, I know we can talk about hypotheticals back and forth all night, but I think that there is a long tradition of courts being able to look at symbolic speech cases and determine whether or not there is a sufficient expressive component to protect it. Whether or not you stew your barbecue longer than other guys do, that doesn't.
So let me come back and let me ask 2 questions of
Yes,
JP
yes.
and then another question of Bob, and then we're going to get Ilya and Sarah in here as well. Newman versus Piggy Park.
Yes.
Two things. First of all, it's a per curiam opinion.
Yes.
That's about 2 pages long, and the part that the civil rights community is citing is 2 words in a footnote that says patently offensive, I think. Is that the
Something
right
like
language?
that. Mm-hmm.
And that's it. Is that really what you want to build this foundation on is one question. The other question is, at the oral argument, the lawyer for the baker, Jack Phillips,
Yes.
argued that you could distinguish race discrimination from this case, because her argument was race discrimination is about the person, and this case is about the message. Can I ask you to respond to both of those?
Sure. So I'm going to refrain from defending the dignity of barbecue here, because I feel like you have just said, can never be artistry, and we have a whole paragraph on, anyway. As a barbecue enthusiast, I take offense at that. But on Piggy Park itself,
Carolina or Kansas City or?
all of the above.
What kind of sauce?
On Piggy Park itself, you're right. There's most of the language is in footnote 5, and I think that's because the Supreme Court knew exactly what they were doing. They were giving that First Amendment claim in that very fraught moment. Also, too, let's remember the historical context in which Piggy Park. This was not a shoe-in case, right? This is after 100 years of history, where religious arguments were regularly used and abused, unfortunately, to justify segregation in public accommodations, in schools, after Brown, in religion. And so we can't just look at that language in the abstract. You have in Loving versus Virginia, a year before Piggy Park, what I think is a momentous repudiation of the use of theological arguments to justify discrimination. And then you have a year later, you have the Piggy Park decision as well. I think the Supreme Court was giving it the back of the hand for good reason. I think the brevity of it Loving was a short decision as well. It was 3 or 4 pages. That doesn't mean it wasn't a momentous decision. And I think if a single member of the Supreme Court had felt otherwise, had thought, maybe there is something to this First Amendment claim, they could have concurred, they could have dissented, but no, it was a unanimous decision, and they gave it the back of the hand on a footnote. So I think that is actually supports the strength of that rejection. I'm sorry, your second question was?
So is that distinguishable from the facts of this case because the
Yes.
lawyer for the baker argued that race was about the individual,
Right.
and this case is about the message?
Well, I think this case is about the individual too, and I think I would take some difference with how you characterize the facts at the beginning, because here's what happened when Mr. Craig and Mr. Phillips and their mother-in-law went into the bakery. They went in, and the whole conversation, even according to Mr. Phillips, was like 20 seconds. They didn't need to start talking about designs or motifs or color patterns or what artists would inspire the cake. All he needed to know was the sexual orientation of these 2 men, and then he turned them way out of hand. And so I think that matters. I think it goes to the fact that yes, they were turned away because of who they are, much like in Piggy Park, the customers were turned away because of who they are.
And Bob, you say baking a cake is different than barbecue, but let me read you the list that the justices asked about at oral argument. Yeah. Hairstylists, makeup artists, chefs, jewelers, florists, wedding invitation and menu designers, dress designers, and photographers. Every one of those was asked about by the justices.
Right.
Where's the line?
Well, first, the easy line is photographers, always yes. That is
Spoken like a true media lawyer. Yes, okay.
well, and spoken like a photographer. And in the other cases, sometimes yes and sometimes no. Just as, under the rule of the Colorado Court of Appeals, said that some kinds of expression are going to be particular enough for us to protect it, and some aren't. You can't get away from those kinds of line-drawing questions, and you have to look at the cases pretty much case by case to determine whether or not there are sufficient element of creativity that it's going to be protected. Just like you do in any symbolic speech case, that's going to be a threshold question. Here, the fact that it was a 20-second conversation doesn't make a difference, because what they're coming in for isn't to buy a cake off the rack, something that's already been made. They're not being turned away from buying product at the bakery. They're coming in for a specific thing, and that is a custom, specifically designed cake for them. The question is whether or not this baker can be compelled to create art that is custom for a particular customer. And so that distinguishes it from a barbecue cook or many of these other people on the list that you
But
get.
not all of the other people on the list. So
Not all of them, no, and that's why I say
Can I
it's
pick up
going
on
to-
that?
Yeah, please.
So Eugene Volokh and I have been filing lots of briefs supporting lots of wedding vendors around the country. Just last week, we supported in the 8th Circuit, we filed one in Telescope Media in the 8th Circuit involving a videographer, as well as in the Kentucky Supreme Court, not in a wedding case, but it was a t-shirt printer that didn't want to print a particular t-shirt for a parade. We did the New Mexico wedding photographer. I mean, this is like kind of the same, print it out, sign it, there you go. But we differ on this case and on Arlene's Flowers. Not because the doctrine all of a sudden is different. He agrees with the way that Bob has explained the doctrine about if you're doing some sort of expressive activity, that gets free speech protection. Eugene just thinks that floristry and baking, cake baking, is on the other side of the line. Look, there are hard lines to draw in lots of different things. Some things are easy to say that are one side of the line or the other in terms of is that protected by the free speech clause. Singing, photography, writing, painting, sculpting. You would say sculptors are artists, right? Well, what is the difference between sculpting with clay or marble versus fondant and buttercream?
Or ice.
Or ice, for that matter. If you look at the, one of the kind of fantastic briefs in this case, the present parties accepted, I suppose, was the one in support of neither party by the cake bakers. We have 27 full-color photographs of these awesome cakes. I mean, these are just incredible. And I think the icing on the cake, if you will, is that it was filed by Baker Botts. But anyhow, there could be hard lines to draw. Maybe barbecue artistry. I'm not exactly. I don't think that one is that
And
hard.
speaking of Piggy Park, here's a
you
cake
make-
shaped like a pig.
Right. You could have barbecue in the shape of a pig. But anyway, on one line are those expressive things that I said, including sculptors. Cake baking to me is like sculpture and that sort of thing. On the other, easy calls on the other side would be like limo driving. There are certain things. And then there could be hard calls. That's fine. Just because some calls are hard to make, I'd be happy if the Supreme Court were having that whole debate. That's not how the debate went, actually. And as a representative of the only organization in the country that filed a brief both supporting Obergefell and supporting Masterpiece Cakeshop, I was a little dismayed that it didn't go quite that way, especially Justice Kennedy seemed to focus on something completely different, not the free exercise clause as presented, let alone the free speech clause, but on whether there was religious animus by the government body involved. Look, if that's the way the court rules, because that's the way Kennedy, as kind of the fifth member of the majority, rules, then that's just punting the issue for the next case, because these things are still stacking up.
So the Solicitor General did suggest a test during the oral argument. Is it a useful one? His suggestion was the question ought to be whether what we're talking about is predominantly art or predominantly utilitarian. Does that work? Does that help? Does that add anything?
It gives you words. I'm not sure if it gives you a solution.
Yeah,
I think that was the court's reaction.
I mean, does it convey a message, right? Because it doesn't have to be. There don't have to be words. Think about what the Supreme Court and other courts have protected, right? An armband, symbolic political speech, exotic dancing, flag burning. Lower courts are protected tattoo artistry. I mean, there's a whole list of things that aren't, writing the next great American novel or pointing or painting Mona Lisa, right?
Well, if I can just pick up on that, because that's one of the reasons why I thought it was important to file a brief supporting those principles, because usually, and in almost every case, when we're pushing back against the government because it wants to restrict some form of symbolic speech, the entire free speech community is in support of the broadest possible interpretation of how you would apply the First Amendment to protect symbolic speech, or art, or music. And here, you see a whole range of briefs, again, by many people I admire, citing those very cases and embracing those very precedents that they fought tooth and nail to oppose. And so
One of the one of the problems here is that this isn't necessarily about speech. Not everyone agrees. Rather, that this is about conduct. Early on you said this isn't about cake, and I agree. It's not about cake. It's about discrimination. It's about Jack Phillips saying that I will provide a service to some people that I won't provide to other people. And I do think the fact that he dismissed them out of hand and was not willing to have a conversation with them really demonstrates that this isn't about speech. Because it could have been that they were simply asking for a plain chocolate cake with yellow roses. But we don't know that because he never gave them the opportunity to flip through the lookbook or have a conversation about whether or not they were asking to purchase the exact same item that he would have provided to anybody else. Nobody is suggesting that Jack Phillips doesn't have a right to say, I think daisies are the ugliest thing in the world, and I'm not going to put them on a cake. I'm not going to put them on a cake for a Christian. I'm not going to put them on a cake for a Jew. What he's arguing is that because this couple was coming in to purchase a wedding cake, and he disagreed with the fact that they were a same-sex couple getting married, he shouldn't have to provide the service. He shouldn't even have to have the conversation with them about what a cake potentially would even look like. He's cut that off at the knees. So, you know, there's a line to be had or a conversation to be drawn around what does it mean if the couple said, we want you to write gay is good all over this cake, right? That's a question about compelled speech. But that's not what this couple asked. This couple never got to that point.
But again, that gets down to whether or not the message is sufficiently particularized. And so the examples that had come to the Colorado Civil Rights Commission and had been decided before, saying that a baker could refuse to have passages from Leviticus condemning homosexuality because then he had a First Amendment right not to deliver that message, not to write that message on the cake. And the question is, how particularized does the message have to be?
But that's a message that he wouldn't have done for anybody, right? So, I mean, in that particular case, that baker would not have done that message for any customer coming in the door.
It depends how you define the message, because he would not have sold to a straight couple a cake that celebrates a gay marriage.
But what is a cake that celebrates a gay marriage? That's meaningless unless it's purchased by a same-sex couple.
Well,
right?
no, I mean, you could have a cake purchased by an individual, let alone a couple, let alone a married couple, that says, you know, Obergefell is great, gay marriage is wonderful.
But is he still discriminating against gay marriage in that instance?
In that instance, he's saying, I won't provide this to anybody. But that's not what happened. That's not the facts of this particular case.
One of the things that the ACLU said in the brief on behalf of the Colorado Civil Rights Commission was that they would agree that strict scrutiny would apply, that First Amendment applies, if the government tried to ban, for example, cross-shaped cakes. Okay, so no words, no message, pure symbolism. Now, there's no particularized message there. You know, why would the First Amendment apply to that?
Except for the context. Because you could see a pastor coming in asking for a church-shaped cake, and you can see a Klansman coming in asking for a cross-shaped cake. So, context matters. You could see a parents.
I assume flambé.
That's good. That's good. You could see parents of a little kid coming in asking for an elephant-shaped cake. You could see Donald Trump's advisors coming in for an elephant-shaped cake. Context matters.
Can I ask a different question about the speech side of this? It came up a little bit at oral argument. It's in some of the amicus briefs. Assuming we're talking about speech, why is it the baker's speech? Why isn't it the couple's speech?
I would argue it's not the baker's speech. That if you, let's use the jeweler, for example. Many people have rings inscribed on the inside that says, to my beloved, to the greatest person ever in my life. Nobody thinks that it is the jeweler who believes that the recipient of the ring is their beloved. It is the speech of the customer that is being conveyed. And in fact, most people operating in the public sphere, the public market, don't actually go through the machinations of finding out who it is that they're selling to. People don't have huge questionnaires. Have you ever been convicted of domestic violence? Is this your first marriage or your fifth marriage? Because as a society, we don't actually believe that you are condoning the marriage of whomever you are providing services for. In fact, I mean, to go down that line would mean that every business in this country would potentially be liable for how their customers utilize any given product. Being a lot for the
But that wasn't the argument. I mean, the argument wasn't, although some made the argument, but I don't think the one that makes any sense. But it is not a First Amendment association case. It's not one saying that because you have a right not to associate yourself with a given message, that is your First Amendment
That's
right.
what would be raised by like a limo driver or somebody who's not
Well, that's
necessarily.
right. That's right. Just as the free exercise argument is sort of this all-purpose defense of discrimination, here I think you get down to the expression. And again, it's the question of whether or not you can be compelled to create a work of art. This was the very question that the First Circuit addressed in the Redgrave case, when the Boston Symphony Orchestra would not be ordered to perform, despite the fact that they had canceled the performance. And the court looked at it and said, we're not doing this because people are going to perceive the BSO as being aligned with Vanessa Redgrave's views on Palestine. We're doing this because simply there is no precedent in all of American law saying you can force someone to do an artistic performance.
Let me come back to JP for a second. If the court rules that this is compelled speech and violates the Baker's First Amendment rights, is there a way that that happens that you think doesn't do some damage to historic civil rights precedents?
I mean, I suppose it depends how they write the decision, but no, I think there's very serious risks of doing, seriously undermining federal civil rights laws or creating such gaping doctrinal exceptions that all the line drawing exercises, I think we have to be clear-eyed about what's going to happen here. There's going to be litigation over many different applications of this new exception. And I admire your attempts to impose some sort of limiting principles here, but I think they're highly illusory. And we would see intensive litigation about all sorts of different businesses. I mean, even under Ilya, I think your brief talks about how many hundreds of thousands of people in the cake industry would be affected. If we look at the wedding industry, that's like 1.2 million employees. If we start...
And how many have we found out object to making a cake for gay weddings?
Well, but...
I mean, this is a minority of a minority.
I don't think we know that, and I think signals in the law matter. And I think how we create doctrinal exceptions matter in terms of the movement of the law. And if we open up this can of worms...
I'm just for protecting minority rights,
I think if we open up this can of worms, there's going to be many, many cases and people trying to evade the otherwise straightforward application of civil rights laws.
Do you think that civil rights law always trumps constitutional principle? And just to put a finer point on it, do you think that the Hurley case was correctly decided?
I think the government has a compelling interest, as the Supreme Court has said, and as the Solicitor General until recently has filed in like a dozen briefs, that the government has a compelling interest in eradicating discrimination.
And Hurley?
Not necessarily rightly decided, but...
there you go.
I'll bite on that one.
Yeah.
Which is to say, I think it's a bizarre application of the law to have ever found a parade to be a place of public accommodation. That is not consistent with public accommodation laws in the vast majority of states and how they operate. I do think it was somewhat of an outlier that the state of Massachusetts interpreted their public accommodations laws to see a parade as a public accommodation simply because there was government involvement in terms of policing the streets that particular day. And it's not consistent with those.
I don't know if everybody knows what Hurley is. Can we just interrupt for a second?
Yes.
Hurley involved the Boston St. Patrick's Day Parade and whether a gay rights group had to be allowed to march by the organizers of the parade. The Supreme Court said they did not have to be allowed to march. All right, go back to your answer.
And that's where the Noel Francisco got his, what I thought was a rather clever line, that if you can't be forced to accept someone into your parade, then you can't be forced to march in a parade either.
Let me check off a couple of boxes here. Does anybody think this is going to be a religion-based decision?
I hope not.
I mean, you'd have to, if you're predicting just based on oral argument, and Kennedy is the one who matters, that seemed to be the thing that most worried him. I mean, it was remarkable. I mean, I was at argument. I don't know, many of you probably read the transcript or listened to the audio, but just essentially cross-examining Fred Jager, the Colorado SG. Do you disown your, lower public official? Do you, I mean, it was quite remarkable. He was very upset by this.
And
who said that we can't allow yet another example of religious bigotry to triumph, or something like that?
Right. I was also struck by the extent to which he followed up on those questions. I don't think that indicates that Kennedy necessarily wanted to go off on the free exercise claim.
That's true.
I saw that more as a viewpoint discrimination basis, saying that Colorado in the past had cut slack to bakers that didn't want to put anti-gay messages on cakes. But on the other hand, here, they put down the hammer on Charlie Phillips because they thought he should have done the cake. And so it's possible that in a narrow as-applied way, the court would look at it as a viewpoint discrimination free speech case.
It's also true that discrimination motivated by religion is one of the major reasons and ways that LGBTQ people experience discrimination in this country. It is extraordinarily frequent in all areas of life, not only for-profit businesses, but in receiving critical services, which the government is funding religiously affiliated entities to provide.
It's one of the reasons I'm an atheist.
And as a result, I think that the court would be reluctant to utilize this particular case as a place to sort of explore the extent to which religion can be utilized as a motivating factor in permitting discrimination.
So we've touched on one of the other boxes I wanted to tick off, which is this a Justice Kennedy case? Like so many other important matters at the court, is this going to come out 5-4 and determines on where Kennedy stands?
It falls right under the Equal Dignity Clause, and we'll see whose dignity is interfered with more, I guess, in his view. But seriously, there is, coming out of that briefing, this theme of dignitary harm, right? Because that goes both ways as well.
Yep.
If you're forced to do something that's against your most deeply held beliefs and forced to do something expressive in that manner, that's certainly a dignitary harm. I forget who it was that I recently read an article actually that said, well, look, there are dignitary harms on both sides. You can't discount it. It burdens Jack Phillips more to have to essentially go out of business because he can't do this in good conscience, literally, than to have the gay couple go down the street less than a tenth of a mile where the next advertised, let alone existing bakery that made gay wedding cakes was.
Well, I'd like to just sort of respond briefly to something you just said, Ilya, which is, there's a lot of somewhat overheated rhetoric about what's going on with Mr. Phillips here. But I think one of the pieces that he's going to go out of business. He could simply stop selling certain types of, if he doesn't want to sell custom wedding cakes to gay couples, he doesn't have to sell wedding cakes.
Well, he has. He stopped them altogether. That's cost him about 40% of his business.
Is he still in business, though?
He's still in business.
Okay. So but just to tamp down on that.
Okay,
I mean,
so we can only curtail 40% of your liberties then. Okay.
No, I mean, if you're not prepared to sell your products on a non-discriminatory basis, then don't sell that particular product. I mean, that's just how public accommodations law works. But I think that this sort of alternative, I mean, Ilya, you and I have gotten into this before about the alternative markets theory of the case here, which is that, you could just go down the street to the other baker. And I think that's problematic for a few reasons. First of all, in the piggy park context, you could still get the products. You could just go around back, right? You just go around. You couldn't eat at the restaurant. You just go around to the kitchen and take the food to go. So there was an alternative market there, or there was probably a black barbecue restaurant down the road. They were separate. No one was saying that there wasn't another market. And in fact, there was a suggestion in this case that the state could just publish a directory of like LGBT-friendly bakers and not. I mean, this happened in the Deep South. There were directories.
The state doesn't need to do it. It's generally advantageous to advertise yourself as gay-friendly.
I'm not sure this is like a great shining example that we want to put our alternative markets theory on. I mean, in the Deep South, black families would have to rely upon like AAA, type guides for hotels and public accommodations that would accept African American customers, right? So this is a sort of a troubling theory, but also we're on K Street right now in the heart of Washington, D.C. So it's a little cosmopolitan of us to just say just go to the bakery down the street. It'll be totally fine. You could just get another. In a lot of parts of the country, that's not an option.
Well, that would be a different case, as the Law and Econ Scholars brief showed.
Why?
Because the original purpose of public accommodations laws under common law, if we can talk about Anglo-American common law anymore after the Jeff Sessions comments today, right, which were very racist. Check your Twitter feeds. It's a huge deal. Right. But anyway,
we'll defend your right to talk about Anglo-American law.
Right. So under original public accommodations law, those arose as against innkeepers. When travelers along the byways of Old England, if they couldn't stay, sleep, and eat at these inns along the road, then they were out of luck. And who knows how many more miles down the horse-drawn road they had to go to find that. And I mean, that's dangerous. It's just not. That's the parallel to the civil rights era, where if blacks weren't served by restaurants or hotels, they had no place to go. And it was effectively a monopoly situation, whether state-supported like Jim Crow or a natural monopoly or what have you. And so, yeah, if there's some sort of establishment where it's the only one for miles around and it's just an impossible burden to go somewhere else, that's just a different case. That came up in oral argument.
But that's not our modern understanding of public accommodations, by far. A public accommodation stretch well beyond this antiquated notion of just, on your travels, whether you can hit that gas station or that hotel. In fact, the vast majority of states that have public accommodations laws actually apply them much more similarly to the Americans with Disabilities Act, which is, in essence, any place that, as a member of the public, you would expect to be able to go and be served. You cannot be discriminated against. Based on your race, based on your religion, in over half of all states, based on your sex, and in 19 states, based on your sexual orientation or gender identity. And that's not even counting all the municipalities all over the country that have more robust public accommodations laws as well. So, I think to sort of structure this and set this up as what public accommodations laws might have looked like in the 1800s versus what they looked like in the 1960s, let alone today, is a little bit problematic.
You talk about the different anti-discrimination laws in various municipalities. We're in a municipality where political affiliation ideology is a protected class. So are you really going to say in DC or Seattle or certain other places that Shepard Fairey, who did the famous poster of Obama, the Hope, right? If he did that, then he has to do an equivalent one of MAGA with Trump, because otherwise he's discriminating based on political affiliation.
Well, so let me ask you about a version of that question, which was probably the most extreme point made at oral argument. The Solicitor General at one point suggested that under the state's argument, an African-American sculptor could be forced to make a sculpture of a cross for a Ku Klux Klan service because that would be consistent with the state's public accommodation anti-discrimination theory. Is that true?
There's an easy answer. Being a member of the Ku Klux Klan is not a protected class
For the
under
Westboro Baptist Church, then.
Sorry, as I was going to say, being a member of the Ku Klux Klan is not a protected class under the state statute. Is being a member of a religious organization protected in the statute? Probably. Yes. Are there a few churches which may also hold similar briefs to the Klan? I suppose. But I just to like this conversation.
So then yes, the gay
not for
would
the
have
cake.
to make the thing for the Westboro Baptist Church.
Well, it depends if they were turning them away on the basis of their religion, or if they say I don't make cakes for anybody.
No, it's not a KKK cake.
No,
It's any cake.
It's a
religiously
themed cake
for the Westboro Baptist Church.
It would depend on whether or not they provide religiously themed cakes to any other customer coming in.
Let's say they do.
If they do, yes. If they bake cakes
What about
in
the
shape
other
of the
example
cross.
that Justice Alito gave, that someone comes in for their birthday cake and they ask November 9th, the best day ever for my wife, right? Someone else comes in and says, I want the same thing. Oh, by the way, I'm going to use this for a Kristallnacht celebration. Same exact cake, same everything, whether it has words or not, but it's like best day ever, Context matters.
Context matters, and is the context of your hypothetical that the speaker is the member, of a protected group? We get a little bit untethered from, there's a statute here, right? We have case law. We can't just riff on, what's an artist what about, we have to look at the actual four corners, and a lot of these hypotheticals don't square with
Right,
that.
and that's the issue that the First Circuit, again, looked at in the Redgrave case, saying if it's got to come down to a question of statutory interpretation versus a constitutional principle, the constitutional principle wins.
Always? What about race? So is Piggy Park rightly decided?
Yes, it was. But here we're talking about a First Amendment principle, and one that the state doesn't disagree with.
So
it
that-
agrees that if someone is expressing their First Amendment rights, then they have an exemption.
So
from
should Jack
Colorado
Phillips
civil rights
be
law.
able? Should Jack Phillips be able to refuse to provide a wedding cake to an interracial couple?
I don't know.
What's the distinction?
Well, again, what it comes down to is whether or not someone can be compelled to create art. If he refuses service entirely, then yeah, he's subject to the Colorado anti-discrimination law.
So he says, I'll serve you a birthday cake. I'll give you cookies for your wedding. But I believe that it is a moral sin for two people who are of different races to marry. Does he have to provide them with the chocolate cake with the yellow buttercream roses that he'll sell to any other customer, but would have to create
Well,
uniquely
again,
for this couple?
your hypothetical always ends with a cake that he'll sell to any other customer. And in the hypothetical, not the hypothetical, but in the facts as were decided, it was creating a custom cake for a particular customer. Whether
it
or
is
not,
custom.
Whether or not someone
get to
can be
choose what color
compelled,
the roses are.
Whether or not someone can be compelled to create art. And again, I have yet to find a single case that says that that is so.
Look, to me, I actually have a further answer. To me, that's a closer case because of the unique history of race and how attitudes against interracial marriage are necessarily indicative of white superiority and black inferiority, let alone other races and whatnot. And so because of that unique history, there could be a stronger argument. I'm not sure which way I would fall ultimately because it's a different case.
Is there a fairly compelling argument to be made that homosexuality was a criminal offense in many states in this country?
But this case is in 2018.
So what?
It's a minority of a
why
minority
isn't the
position.
history the same?
I'm not sure the state's interest is so compelling to make sure that every last dissenter from the overwhelmingly prevailing view bends their knee to the orthodoxy.
Well, I hardly think it's an overwhelmingly prevailing view. Just over 50% of Americans today support marriage for same-sex couples. I mean, that doesn't make it, rampant.
Yeah, but in
belief of
D.C. or in
equality.
Colorado, I mean, it's different in different places, I would argue.
So we should
This
have
is-
non-discrimination
in Jim
laws
Crow,
in
it was the majority,
Alabama,
it was
but
the-
not D.C.
It's just like Shelby County. You can only justify certain temporary emergency inversions of the normal operation of constitutional law when you have extraordinary circumstances on the ground.
So here's where I struggle, right? Here's the problem. Is it only when LGBTQ people have adequate political power to be able to change the conversation and to ensure that there is an opportunity to prohibit discrimination do we have laws like Colorado's? Where, Jack Phillips notwithstanding, you're right. I think that the incidents of discrimination in a place like Colorado happen less frequently, but Alabama. But there are no protections. Well, actually, that's not quite true. There are some protections now. Limited protections for LGBTQ people in Alabama, which is where the discrimination is most likely to occur. So should we then mandate that Alabama has non-discrimination protections and that every Jack Phillips in a deeply southern state?
Well, it depends what you mean by
Provides
anti-discrimination as well, whether it involves creative expression or not.
So then Jack Phillips gets to discriminate against the Jewish couple, Muslim couple.
If he disagrees with interfaith, if there's a Catholic baker that doesn't like interfaith weddings or remarriages after doesn't recognize divorce, I would argue that in a creative expression type of profession, yes.
Mm-hmm.
And by the way, I disagree with Bob on his characterization of like the worst scoundrels and all this. I've met Jack Phillips. I know his story. This is not the same thing as the Westboro Baptist Church, let alone the Piggy Park racists and the
I
civil rights
wasn't
era.
speaking of him personally.
Okay.
So I don't think we need to cast aspersions on or really go there about the particular petitioner here individually to say What
People generally, as Kennedy wrote in Obergefell, who disagree with same-sex marriage.
Sure, that's not the purpose of my analogy. The purpose is to look at history and see where history and precedent is relevant to the questions and issues that we have at hand. And also ask, like, what do we want, if you think at best this is a gray area, then which way do you want to push the law, right? What do you want the country to look like? Do we want to have a host of new constitutional exceptions for people who don't like interracial marriages and don't like interfaith marriages, which did come up in oral argument and which they kept open? I mean, it opens up a whole can of worms.
Well, it does. I mean, the point that was just being made, that do we only solve this through having sufficient political power? Well, do you really want a country where there is sufficient political power, not just to force change, which was long overdue for same-sex marriage, but also to force people to agree with you, to essentially sign loyalty oaths saying that I will not discriminate
Jack
against...
Phillips doesn't have to agree. I mean, he's welcome
he has
to
to train all his bakers
participate.
for a period of 2 years and report every decision he makes about a cake.
He's welcome to participate in a religious faith that condemns homosexuality. He is welcome to write op-eds in the local newspaper saying that LGBTQ people should be recriminalized. That is part of his First Amendment rights. What Colorado is saying is not about what his cake actually looks like. He does get to dictate whether it's a mermaid cake or whether it's, a standard white cake with lace on it. What he doesn't get to do is to say, I'm going to pick and choose amongst my customers because I have a profound dislike for a particular group of people who are exercising their constitutional right to marry.
One of the things that I've found troubling throughout this entire case is that when people talk about the First Amendment interests, they start from the presumption that they're trivial and that they're just not important. And having fought so many battles over the years involving rights that people have denigrated, saying, that right's not important. You're not talking about something that is significant enough to me or to the body politic that we're not going to protect it. That's one of the reasons why the justification of the Colorado Court of Appeals saying that just isn't specific enough communication for us to protect it. If it's more specific, we'll protect it. And, to me, the sort of the dismissive attitude toward the First Amendment issue is problematic.
I don't think it's dismissive. I think there's a genuine disagreement in which many people believe that what's being regulated here is conduct. It is not the message itself, and that, to the extent that Jack Phillips is creating a cake, that again, and I really am stressing this because I do think the facts become different if it is not a cake that he would make for everyone else or a style of cake that he would make for everyone else.
If I had a nickel for every time someone said, that's not speech, it's conduct, then I could retire today. There are cases involving tattoo artists where essentially the government's argument was that that's not art at all, it's simply conduct. And one of the things that the Ninth Circuit said in that case was that all speech involves conduct, but we never break it down to its constituent parts and say, you use those kinds of brushes or you use this kind of material. Instead, we look at whether or not what you have done is expressive. And so that's why I think the threshold question here is whether or not this baker is someone who held himself out as someone who does unique designs and expressive works for that purpose. And the record, at least, is undisputed. That he saw himself that way, and that's how everyone else did too.
But I take it you don't quarrel with that there is at some level a distinction between conduct and speech.
Of course.
And that we may just draw the lines differently, because otherwise you're talking about, a car involves product designers and artists and people.
I'm not sure that you're even that close, because you would be arguing on the other side from me, at least. I don't want to speak for Bob, in the New Mexico photographer case or the videographer case. I don't know where you stand on wedding singers, but they're singing other people's music. It's not their own music, but
publishing a newspaper is a whole lot of conduct.
Sure.
I'm going to take the moment to throw this open to the audience. I'm going to end, though, on one note I think we could probably all agree on. The case won't turn on Justice Alito's comment that he's never had a good wedding cake.
Gorsuch.
Was it? I think it was Alito. But we would love to open it up to questions in New York and in Washington. We'd love to hear your thoughts and questions for the panel.
And please identify yourself when you ask the question. And in New York, don't hesitate to exercise your First Amendment rights. The same thing here in Washington, D.C. So.
So I have a question. Can you hear me?
Yep.
Yep. So I'm getting hung up with Bob's, conduct versus expression issue, because it would be one thing if the baker said, I am not going to decorate, I'm not going to make a cake that shows two men, kissing, because that's the expressive conduct I find is a violation of my religious beliefs. But it feels like what he was actually saying is, I am not going to make any cake that is going to be sold to these two individuals. And that seems much more like a conduct issue than it is about the art that he is creating or not creating.
I think the issue there is that many people look at this as a symbolic speech case like United States versus O'Brien, where you're talking about burning a draft card, where the idea is the conduct itself is what is expressive. And the argument here isn't that Jack Phillips' use of his oven is somehow expressive. The idea is what he is doing is creating an expressive work. And the question is whether or not someone can be compelled to create art.
Go ahead. Please identify yourself.
Mary Ann Zimmer. And Bob and I have spoken about this case some time back. Correct me, Bob, if I'm mistaken. I had understood that in the facts of the case, the baker was willing to sell the cake with all the nice flowers, and the baker was very well known for making gorgeous flowers and beautiful decorations. And that the baker was willing to sell the plaintiffs a plain cake, but the plaintiffs wanted to have something written on it. Now, am I mistaken about that?
You're mistaken.
Now, whether it was a matter of the baker having to write, "Here's to Dan and Bob on their wedding." In other words, the cake would be the same as anybody else's cake, but I thought it was a matter of what they wanted to have written on their cake.
And
Never got that far.
The discussion never got that far. And as a matter of fact, if that had been the facts, then the Colorado Civil Rights Commission might have gone the other way, because they said that if it were a particularized message, that the baker could stand on his rights under the First Amendment. So,
And I believe actually Colorado and the ACLU are on opposite sides of that question.
Maybe.
But there is a split on the other side about that.
Again, the ACLU, in its brief, said that if you had a state regulation that prohibited cross-shaped cakes, that would be subject to strict scrutiny. But the question is, whether or not what he was being commissioned to do was to create art, something artistic. And the question then beyond that is whether or not the First Amendment protected his right to refuse to be compelled to do that.
And to be clear, they were permitted to come in on the day of their wedding and pick up something that was already in the case. He wouldn't even allow them to say, so this one that happens to be in the case today, I want you to make that for me so that I can guarantee I can pick it up 5 days later.
There was a California court that just decided a wedding cake case within the last week or so that addressed this issue, and it said the difference was between selling a cake and being required to make a cake.
I discount that because even though it went my way, it's a California court. I prefer American courts.
Just to add one little twist on, I think we're all assuming that if the couple had come in and asked for the cupcakes, or they would have given her the cupcakes, he could have just done that. It's actually, I'm not sure if this made it in the appellate record, but there's actually some suggestion that he also refused cupcake orders from gay couples, so that there was just he just didn't like serving and selling things to gay couples, and I think that's the inevitable undertone of this case.
Somehow that never made the record.
Yeah, right, but it has been well reported.
We all have our own hypotheticals. This is Floyd Abrams. The one that has stuck with me the most is if an artist offered two sorts of services in his gallery, which is open to the public. One, he has paintings around the room, which he will sell to anyone. And the other, he has a sign that I will paint portraits of you for $250. And his policy is he will not paint portraits of gay people, or black people, or Muslims, or Jews. And a state body applying an anti-discrimination law says that violates our law. Bob, do you or people who agree with you think that in that circumstance that the statute would have been unconstitutionally applied? Just to continue, I don't do this as compelling anyone to paint. What I'm talking about is a statute, and I think the statute in this case is like that, is saying you can't discriminate. If you're going to paint, and your First Amendment protected no less in what you paint, you can't have a policy of turning away people that you would otherwise paint but for the fact that they're black or Muslim.
No, that's a very hard hypothetical, and it's one of the reasons that at the outset I said that makes this case a very difficult case. I think of the two questions that were decisive to me, the first question is whether is it art, and the question is, in your hypothetical, unquestionably yes. You're talking about an act of creative expression. And the second question is, can you compel someone to do it? Now, as you say, well, you're painting it for everybody else, then you're not being compelled to do anything. I think once you're being compelled to create an expressive work against your principles, then you've got a very difficult First Amendment problem to solve. I think it's different from this case because it is more extreme, but you still have that very difficult First Amendment problem to overcome, and it's the one that the First Circuit in the Redgrave case found no answer to. It could not find a single case in which someone was forced to create an expressive work.
But the forcing is you're being forced not to discriminate.
Well, and in that case, it was argued that it was a violation of the Massachusetts Civil Rights Act because it was violating Vanessa Redgrave's civil rights. And so again, it's really very analogous.
It's George Freeman, doesn't the fact of what you're being asked to paint or to do on your cake matter more than maybe you've discussed so far, partly because it's not in the record as to apparently that conversation. But it seems to me there might be different results if two gay people come into the cake shop and say, make us a nice cake. We don't really care what's on it. We hear you're the guy. You can create whatever you want for us. That's one case. The other case is they come in and say, we want a cake with two guys screwing each other as the picture on the top of the cake. I could understand why this baker might object to doing that. But aren't those two cases pretty different, leading to different results?
I'll answer that hypothetical with yet another hypothetical going back, in that Floyd's example is indeed, I agree with Bob, a harder case than that same painter who says, I will paint your wedding portrait but not gay wedding portraits. Because that's what this case is, right? He's like, I'm happy to paint gay people, but I won't paint them at their wedding. I'm happy to paint them at their birthday celebration, their retirement celebration, whatever it is. The wedding thing is, for me, a bridge too far.
But isn't Floyd's hypothetical that all they're being asked to paint is the guy's face? There's not a lot of discretion in that. I mean, how can he be opposed?
The problem is compelling art. But that's what makes it hard is that it's discrimination based on status. Whereas here, Bob and I hold that it's you're talking about a particular event or a symbolic meaning that you're being forced to convey.
Well, but I actually think it's. Look. So this is where I come from. Y'all don't work enough in LGBTQ issues. If you don't want to do a penis cake, you don't have to do a penis cake. You don't have to do a penis cake for anybody. right? If that is your line, is that you're not going to do something that's lewd.
Actually, in some of the people I represent, they'd be very upset if you didn't do a penis cake. And so, how can you claim that your line
I'm
is
the only
there,
person who's
somebody
ever
else's
printed a
line
full color
should be
beer
somewhere
label
else?
in a Supreme Court brief?
Because it's not about, what we are talking about in this particular case is whether or not the baker would provide the exact same service to this couple that he would do for any other couple that came in, right? I mean, the facts of this case are not about a couple requesting a cake that was unique from any other cake that he made. He, again, like I use the daisy example, if he thinks daisies are ugly, he doesn't have to put the daisies on any couple's cake. But what he can't do is say, I don't do any cakes for you simply because of who you are. And I will too, I'm going to open it up because I'm going to be honest, like I'm more of a civil rights lawyer than a First Amendment lawyer. It is my understanding as well that when we're looking at what constitutes art, one of the things that the Supreme Court has historically looked at, or the federal courts have historically looked at, include things like what is the primary purpose of the good that is being created? Is it intended to be something that is short-term or long-term? I mean, that these are factors.
Right. And I saw those arguments in the briefs. And the problem there is, if you accept that as your standard, then no cake can ever be expressive, right? That even the hypothetical that the ACLU accepted, saying that Bible-shaped cakes can't be banned unless the state meets the strict scrutiny standard, that wouldn't matter because you've already adopted a rule that edible goods can't be artistic, can't be protected by the First Amendment. And that would be true no matter what you wrote on it, right? If you're saying that, hey, its primary purpose is to eat, so, what the hell? There's no First Amendment issue here, even if you write the Magna Carta on it. So I think that...
I mean, I would argue that the primary purpose of a wedding cake is not to eat it. Like a normal standard cake, for dinner, that is the purpose. But for a wedding cake, it's... and I probably didn't know this until I got married because I was, with my wife. I got to participate in the tasting. That was delicious. But, it's a symbolism of, the union. And you're celebrating this thing. And that's why it's symbolic and conveys a message, even if there's no words on it or a rainbow flag motif or whatever.
Sorry.
I have two-part question. Identify myself. Ricky Levy. If this had been a couple, a black or a brown couple who came in, and they were stopped 20 seconds in the door and told, sorry, you need to go, would this be a different case?
Well, it would be if you didn't have, again, the offer to sell anything else in the store, right? That's one of the things that distinguishes this from Piggy Park, where you have someone stopping you at the door saying, we don't serve your kind. Those weren't the facts here. The facts were, and again, I don't know what wasn't in the record. I can only tell you what was in the record. And according to the record, they were offered to buy anything else, just that the baker would not do a custom-designed wedding cake.
If you were to win this case...
it's not my case.
If someone is to win this case in favor of the baker, did we not then enshrine discrimination?
Depends how you define discrimination. Any choice is discrimination. I'm picking that, not that. I want to do that, not that.
I don't want to do the penis cake.
I think a more honest answer to your question is yes. There is a way in which it is not impossible that the court says, as was argued by the U.S. government, that race is different and should be treated differently. But if we're going to open up this idea that this is compelled speech as opposed to a regulation of conduct, this is absolutely going to have consequences for non-discrimination laws that have been on the books for generations at this point that prohibit discrimination on the basis of religion, that prohibit discrimination on the basis of sex, and yes, that prohibit discrimination on the basis of disability status.
Before the skies fall here, keep in mind that Colorado has already said if the message is sufficiently particularized, the baker can already refuse to do that. And there are decisions involving photographers as well, and now in California, another baker. So again, the issue isn't
In New
whether,
Mexico, though, a photographer can be compelled.
Well, that's right. And so there is, the law is in a state of flux. But, you know, the question isn't whether or not public accommodation law trumps the First Amendment. The question in all of these cases has come down to, is there a sufficient First Amendment question here to justify the baker's decision? And to say that if the Supreme Court supports the baker in this case, it's going to mean you'll have many more of these cases. You already have these cases involving the baker who doesn't want to put Leviticus on the cake and all of the others. And so we're going to have litigation in this area, whichever way the case gets decided.
Question.
Can I ask a question in New York? This is Alameen Sumarman, associate at Ballard, Spahr. I guess my answer to that would be, why doesn't this law pass strict scrutiny? You say this is a line drawing exercise, but like, obviously the line that you draw permits a lot more discrimination in the service industry, and it opens up a lot more discrimination towards all kinds of people. So why isn't it totally legitimate for the state to say, we have a compelling interest in avoiding discrimination, avoiding rampant discrimination in the service industry?
Because it's not rampant. It's a minority of a minority.
No, but I think we agree. I mean, I was convinced by Eugene Volok's brief that this kind of reasoning applies to lots of other fields and specialties. And, I mean, Bob, I don't even know you, but I'm calling you Bob. Bob, you hesitated.
How you doing?
You hesitated on the race question. And you don't, there's no good answer to a lot of these questions, so why doesn't this law
No, the
pass
race question is difficult because of our
How would you
history,
ma- how would
and
you
as
make
the
this
court
law-
recognized in Black versus Virginia.
How would you make
and
this law
treated
more
that
narrowly
differently.
tailored? How would you make this law more narrowly tailored?
I'm sorry?
How would you make the law more narrowly tailored?
I'm not sure. Well, I'm not sure the answer is in reforming the law. It's in how you apply the constitutional analysis. And again, you have on the one hand, Colorado saying that we will protect your First Amendment rights if your message is sufficiently particularized and offends you, but we won't protect your interest if you're simply an artist. And so I think refining the constitutional analysis is a better way to go than trying to rewrite a law to target specific kinds of activities by people in the service industry. There's a question, man.
Yeah, back here.
Yeah, I'm probably already fairly represented on the panel, but if you say that the basis of this public accommodations law comes down to protected classes, my question is, how do you, in the event of an expressive business, wherever you happen to draw that line, we agree that there are going to be some businesses that are involved in expression, how do you prevent application of the law from being viewpoint-based? Because you're only protecting certain classes, and you're only favoring speech that, or disfavoring, depending on your viewpoint, or how you look at the question, you're only doing it on behalf of certain individuals or groups, and how you feel or express about them or not.
The short answer is the author of RAV is no longer with us, but
I mean, I just don't think that's how the law has evolved or framed it. I mean, I don't really think of like Piggy Park or Loving as engaging in viewpoint discrimination against racists, right?
No,
We just,
because they weren't First Amendment expression cases. They
sure,
were
Piggy Park was. Yes, it was.
No. It was a free exercise case.
Every time you've opened your mouth here, you've presumed away the expression to get to the answer. And I understand why that's the easy way to do it. Let's assume that there is some subset of businesses where you're involved in expression. Let's take out the ones that aren't expressive, wherever you draw that line. But for those businesses that are involved in expression, if you're saying you can discriminate against someone like me because I'm not in a protected class, but you can't discriminate against this person, how do you avoid that being viewpoint discrimination?
Well, so one thing I would answer is that all people are protected by civil rights laws, right? I mean, so our civil rights laws don't protect people who are Black, they protect all people from discrimination on the basis of race. Our civil rights laws don't protect women. They protect all people regardless of how they understand their sex. Same with sexual orientation or gender identity. It's not like the gay bar gets to discriminate against a straight person. That is actually impermissible here in the District of Columbia and other places.
Age and disability don't work that way.
You're right, age and disability don't. But the vast majority of our civil rights laws are structured so that if you are talking about everybody who is protected by those laws.
I think there was another question back here, yeah.
David Keating. I was struck, look, I didn't read the briefs and I read them quite a while ago, so I don't remember all the details, but I was struck by the briefs on either side, and then today's discussion. I'm not really sure I understand what the actual facts of this case are. Everyone's laughing. But so, I mean, we hear that it's based on who came into the store and that it's based on expression. I'm very confused about this. I'm being tugged both ways. I really don't know what the facts are. And is there some way, I mean, maybe the court should the court kick this back and say, well, what really are the facts? Or
Continue your conversation another 20 seconds and we'll see what happens.
Actually, I do think we all agree on the facts. I mean, I think every single one of us has framed up the facts fairly consistently, which is this gay couple walked in the door. They sat down to have a consultation about a wedding cake, and were told at that point, because they were a gay couple, that the baker was not going to continue to have a conversation with them about creating a cake for their wedding.
Right. You can buy anything else that's already in the store, but I'm not going to create a cake for your wedding because it's between two people of the same sex.
And you can't pre-order, correct?
And you can't pre-order.
I think there's a question in New York.
Yeah, a quick question. I'm Matt Schaefer, by the way. This is picking up on what Sarah said earlier. What's the response to the argument that "to my beloved" is clearly not the jeweler's speech, but rather the speech of the individual who's paying for the service? The response from the other side.
Oh, the point is, it's not that you're attributing the message to the baker, right? The point is you're being forced to create a work of art.
Yeah, even if there's like a 50-foot high sign on the way into the wedding reception saying this cake, the maker of the cake disagrees with the message conveyed by the cake.
Well, that's right.
That doesn't remedy the issue because the issue comes when the baker is forced to add that secret ingredient of love, if you will, to the cake.
And the point is,
inscription.
Representational art doesn't send that kind of message. It's not like if you have a message, go to Western Union, right? We're not talking about that kind of particularized message. That was the error that the Colorado Court of Appeals made. The issue is whether or not someone is creating an artistic work and whether or not the government can compel the person to do that.
I do think Ms. Wagner did, the lawyer for the baker, did sort of keep the door open, though, to a freedom of association claim. She said, well, we just didn't, in response to the Chief's question, she said, well, we just didn't bring that claim, that he wasn't participating directly enough.
I think wisely.
Well,
right.
In returning to Floyd's point about the artist, I mean, I think if I'm Candy Wiley and I'm interested in painting,
Can you speak closer to your mic, wherever it is?
Where are the mics? I'm just thinking if I'm Candy Wiley, this is Bobby Bertoni from New York, and I'm interested in painting portraits.
We can't hear.
You want to come up front?
Try standing up.
Take the stage.
If this works at all, if I'm
That's better.
Candy Wiley painting portraits of successful black people, as an evocative of the Dutch masters, say. And I'm really not interested in painting portraits of successful white people because that's not what my art is about. My art is about celebrating black life and black culture in this very specific way. And I accept commissions, right? People can come to my studio and meet with me and discuss what I would do for them. But I'm just not painting portraits of white people because that's not what I'm interested in exploring as an artist. I think I am free to discriminate in that way. I think I am free to discriminate on the basis of race in painting a portrait. I can't be compelled to paint portraits of rich white people. So I think we are back on a wedding cake that you sell in a restaurant that's open to the public is more of a commodity, and in fact is not the same as a Kehinde Wiley portrait. It's just not.
Wait. So your distinction would be if he has a storefront. If he doesn't have a storefront and it's all by commission, then it's different?
In a sense, if it's a commodity, if it's a commodity good, I mean, maybe this is a malformed idea, but if it's something that is, you know, if I have a cash register in the front of my store and I'm ringing up sales, that's not the same expressive act as a photographer, painter, or writer.
So you can discriminate with a Rolls Royce, but not a Ford?
I don't know.
The similar answer. It's interesting. All the artists' studio questions are really interesting. The simpler answer may be it depends how the statute defines place of public accommodation. If
a parade, for example.
Right. Yeah. If it describes it as a business that's open regularly with a storefront, and you have under federal law, you know, a certain number of employees, and there's a threshold, then the artist who's cooped up in the attic, who only takes appointments twice a year, might not, under the statute, qualify as a place of public accommodation.
But I'd be willing to go further. I mean, so let's assume that this artist who only paints pictures of powerful African Americans has a storefront, right? Someplace in New York. You can go in, and what he offers is a degree of customization. He'll do it in different sizes. He'll put a different wash on the picture that he's done. Now, I think he gets to control what the content of that painting is, right? He gets to control whether or not he paints white people or black people, but he doesn't get to refuse to sell the blue-washed version to the rich white person.
Isn't it also a matter of the intent of the artist? To the extent that the artist is being absolutely upfront and is saying, in effect, what the baker claims he was thinking, etc. If he said, the reason that I won't paint black people is because I believe the Bible is purposefully derogatory and harsh on black people. They are unworthy, in my biblical reading, of being painted. I think the state has more of an interest in that case and more of a justification in applying an anti-discrimination law than in your very thoughtful hypothetical about an artist who chooses to be an artist rather than a tradesman, and an artist who has a notion, right or wrong or serious or unserious, of art. My example was deliberately focused more on, you know, come on in off the street and I'll do your painting. But I would certainly acknowledge, look, that this is an area with hard distinctions sometimes. Every anti-discrimination law is at tension in some way with the First Amendment when there is speech or expression at issue. So we're necessarily in an area in which different fact situations and for an anti-discrimination law, different motivations or different impact on the people who aren't being painted will lead to different results.
Maybe we'll make that one more question, and then we'll quit.
I have a question for you, Turner. Bob, in your analysis, if you win, if that analysis wins, can the baker put...
It's not my case.
No,
I filed an amicus brief.
If that analysis wins, can the baker put a sign on the front of the store saying, I don't make special cakes for gay people?
I don't make wedding cakes for gay people.
All right, I don't make special wedding cakes for gay people.
Probably so. And in the same way that I don't think the state would be able to force someone to put a sign in the window saying, here's what I believe about, or here's what I don't believe about gay people or anyone else.
I wasn't asking about forcing him to do it. I'm asking if he is permitted to do it.
Yeah, and I think they
You
would.
think so? Okay.
Some people would prefer that because then you don't have to have that awkward conversation where you walk in and they're wanting to have this cake and then they're blindsided. Oh,
Yeah, and
that's, you know.
one of the things about the California case that was just decided, and sorry, it's California, is that the baker had a cooperative arrangement with another baker that didn't have a religious concern about doing same-sex wedding cakes, and so she referred the couple to the other baker.
He could already put a sign in the window now saying, I don't support gay marriage, right?
Yes.
Nothing stopping
That's
that.
right.
If you found your mind going back and forth from one view to another, you owe it to Sarah, Ilya, Steve, Bob, and JP for engaging in a wonderful discussion. Will you join me in thanking them? Here in Washington, D.C., we have wedding cake for folks. And otherwise, we will see you on April 27th at the Floyd Abrams Institute in New Haven. Good night.
Thank you.